Thanks. That was nice to get a little bit of applause. So it is my pleasure to introduce to you today Judge Diarmuid O'Scanlan, and to officially welcome him and Mrs. O'Scanlan back to Notre Dame on behalf of the Federalist Society, the Notre Dame Program on Constitutional Structure, and the entire law school community. So I'll keep my introduction brief and to the point. Before and after receiving his law degree from Harvard Law School, otherwise known as the Notre Dame of the East, the judge has devoted almost his entire professional life to public service, to U.S. military service, to state governmental service to the executive branch of the United States government, and most recently and significantly in service to the United States judiciary. Judge O'Scanlan joined the Ninth Circuit Court of Appeals in 1986, having been nominated by President Ronald Reagan, and then, of course, having been confirmed by the United States Senate. His contributions to the fair application and administration of the laws of the United States are far too numerous to mention, so I will just take a moment to tell you a few things that you may not know. I don't want to put words in the judge's mouth, but the judge, in his own words and actions, has demonstrated as strong a commitment to rule of law values as you'll find on the federal bench. And by that, I mean a commitment to the proposition that the fair and impartial administration of the law and the governmental stability that results from that is, over time, the best and surest protection of human rights and fundamental liberties. On the basis of this commitment, the judge has long gone well above and beyond the basic demands of service on the federal bench. His Court of Appeals is large. It encompasses his home state of Oregon, Washington, California, Arizona, Nevada, Idaho, Montana, Hawaii, Alaska, Guam, the Northern Mariana Islands, and I am sure other U.S. territories that I don't even know exist. The case law that this court generates is enormous. It's varied, and as one might expect, at times it's inconsistent with itself and with the decisions of other U.S. courts. The judge has made, in my estimation anyway, positively Herculean efforts through the years to promote consistency on his own court and in the courts of appeals generally by invoking the en banc process in the Ninth Circuit, and where that fails, by writing thorough and learned dissents from the court's failure to hear the case en banc. These, quote, dissentals, as they are called, are the functional equivalent of sending the bat signal to the Supreme Court of the United States. Not really, but they have had, it's true, they have had an enormous impact on flagging those cases from the Ninth Circuit in which the nation as a whole may have an important interest. The judge frequently lectures on the rule of law, as well as on specific legal topics that warrant broad consideration in the United States at large. On a personal level, I clerk for Judge O'Scanlan, and the judge has taught me more about the importance of law, public service, and honest discourse and decision-making than I will ever be able to repay. So today, speaking on affirmative action at the Supreme Court, it is my pleasure to introduce Judge Diarmuid O'Scanlan, United States Court of Appeals for the Ninth Circuit.
Thanks, AJ, for that very, very fulsome introduction, if I may say. It is always a pleasure to return to Notre Dame Law School, an institution that's very, very dear to me and to Maura, my wife. As the father of two children who earned their law degrees from this law school, and as the recipient of an honorary doctorate a few years ago, I regard Notre Dame, my home away from home. I'm especially pleased to be addressing the Federalist Society chapter here, an organization that plays a vital role in this and other campuses across the nation in fostering respectful, reasoned debate about a range of legal topics. Today, I would like to talk to you about Schuette versus Coalition to defend affirmative action. That's the name of the Supreme Court case, which was handed down last term. The court in Schuette had to determine whether a voter-approved amendment to the Constitution of the state of Michigan, which eliminated racial preferences in college admissions, was unconstitutional under the Equal Protection Clause of the 14th Amendment. The case gained significant media attention because of its implications for affirmative action programs, but it was perhaps more important because of its strong vindication of the right of states to decide questions where the federal Constitution is silent. And while these two issues garnered the headlines, Schuette is important for a third reason as well. The decision exemplifies the importance of language to the judicial process, and as we shall see, the case involves the justices parsing the text of the Constitution, engaging the prose of existing judicial precedent, and carefully crafting their own writing in an effort to shape the future of equal protection jurisprudence. Such an emphasis on language is part and parcel of the judicial role and of the practice of law generally. Schuette originated in your neighbor state of Michigan, which has been the source of many recent affirmative action cases. But Michigan is not the only state to have played an important role in the history of affirmative action jurisprudence. California, located within the jurisdiction of my court, has also been at the forefront. 10 years before Michigan voters went to the polls, California voters amended their state constitution to prohibit racial preferences in university admissions by passing Proposition 209, which gave rise to a case called Coalition for Economic Equality versus Wilson, commonly referred to, and I will refer to it here, as the Prop 209 case. Now, as it happens, I wrote the opinion for a unanimous three-judge panel in that case, upholding the right of the people of California to enact Proposition 209. And incidentally, sometime you might collar Professor Belia and ask him who the law clerk was that helped me on that case during that year. Accordingly, I will begin the discussion of the constitutional question in Schuette, which is whether and in what manner voters in the states may choose to prohibit the consideration of racial and other preferences in governmental decisions. And I'll compare that with my own experience in the Prop 209 case out of California. Well, on November 5th, 1996, California voters approved Prop 209 by a margin of 54 to 46, with nearly 9 million Californians casting ballots. In passing Prop 209, California voters amended their constitution to read, and I'll quote the change: "The state shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting." The day after the election, several groups filed a complaint in federal district court in San Francisco, alleging that Prop 209 violated the Equal Protection Clause of the 14th Amendment. The trial judge agreed with the plaintiffs and issued an injunction. California appealed that decision, and the case arrived at the United States Court of Appeals for the Ninth Circuit. Before I move to the merits of the equal protection claims presented in the Prop 209 case and Schuette, I should give a brief overview of the relevant doctrines implicated in these cases. We begin, as always, with the text. The Equal Protection Clause of the 14th Amendment reads, "No state shall deny to any person within its jurisdiction the equal protection of the laws." Well, now, of course, the requirement of equal protection does not mean that the state may never draw distinctions among classes of people. In fact, most classifications only need a rational basis to be compatible with the Constitution. However, there are a few classifications that demand heightened scrutiny. For instance, the Supreme Court has said, racial and ethnic distinctions of any sort are inherently suspect. Therefore, any classification based on race must pass the most exacting judicial scrutiny. It must serve a compelling governmental interest and be narrowly tailored to achieve that interest. In a line of affirmative action cases, the Supreme Court has held that the Equal Protection Clause permits narrowly tailored race-based preferences that serve the compelling state interest of educational diversity. However, as the Court has made clear, the ultimate goal of the Equal Protection Clause is to do away with all governmentally imposed discrimination on the basis of race. Well, now, you may find yourself wondering how the California and Michigan constitutional amendments, which I read to you, prohibiting race-based or sex-based preferential treatment could ever be deemed to violate equal protection. In fact, these amendments simply codify into their respective state constitutions the very purpose of the Equal Protection Clause. As a matter of conventional equal protection analysis, you would be correct. There is simply no doubt that these amendments are constitutional. But there is a second strand of equal protection analysis called the political process doctrine, which concerns itself with how the state structures its decision-making process on racial issues. To understand what the political process doctrine is and when it is triggered, it is helpful to examine the cases from which it arose. And before I begin that, I want to emphasize that this forthcoming discussion reflects my understanding of these cases at the time of the Prop 209 case, which was, of course, pre-Schuette. The Supreme Court first applied the political process doctrine in a case called Hunter versus Erickson. There, the court held that an amendment to the charter of the city of Akron, Ohio, preventing the city council from enacting ordinances dealing with racial discrimination in housing was unconstitutional. The court's rationale was twofold. First, the initiative dealt only with racial housing matters, thus having the effect of treating racial housing matters differently than other housing matters and other issues relating to race. Second, the initiative changed the decision-making process in such a way that it made it more difficult for those who ostensibly benefited from such a program to enact legislation. And there was a second case called Washington versus Seattle School District Number 1. The court applied the political process doctrine to desegregative public school busing. In 1978, the Seattle School Board adopted a plan of mandatory school busing to improve the racial integration of its schools. Opponents then passed a statewide initiative to stop such busing. The school board then sued, alleging an equal protection violation. The court held that an initiative precluding such busing was unconstitutional. It did so for two reasons. First, desegregative busing inured primarily to the benefit of the minority and was designed for that purpose. Second, the initiative used the racial nature of an issue to define the governmental decision-making structure, thereby imposing direct and undeniable burdens on minority interests. Now, as these cases demonstrate, prior to Schuette, the political process doctrine stood for the principle that state action which structures political institutions or allocates governmental power non-neutrally by explicitly using the racial nature of a decision to determine the decision-making process violates the Equal Protection Clause. And so we arrive at the Prop 209 case, Coalition for Economic Equity versus Wilson. The constitutionality of Prop 209 turned on whether it could be distinguished from the initiatives in Seattle and Hunter. My opinion for the Ninth Circuit held that Prop 209 was indeed distinguishable from those two cases on two grounds. First, in order to violate the political process doctrine, it must be shown that the state reallocated decision-making authority in a discriminatory manner. In Crawford versus Board of Education, the Supreme Court recognized an explicit distinction between state action that discriminates on the basis of race and state action that addresses in neutral fashion race-related matters. Whereas in Hunter and Seattle, the state had erected barriers to enacting policies to remedy racial discrimination in discrete areas like housing and busing, Prop 209 prohibited all state instruments from discriminating against or granting preferential treatment to anyone on the basis of race. Such measure, in other words, repealed all race preference policies and restored racial neutrality in precisely the way the Crawford case said was permissible. Second, as our cases have consistently held, equal protection is an individual guarantee, and as I put it in our opinion, the political structure cases do not create some paradoxical exception to this element of any equal protection violation. In Hunter and Seattle, the lawmaking procedure made it more difficult for certain individuals to obtain protection against unequal treatment. In contrast, Prop 209 made it more difficult for anyone to receive preferential treatment. Impediments to preferential treatment do not deny equal protection, we said. Thus, as Prop 209 reallocated decision-making authority in a neutral fashion and did not burden an individual's right to equal treatment, our opinion for the court held that it did not violate the Equal Protection Clause. And as I said at the time, we must not lose sight of the forest for the trees and remember that the 14th Amendment does not require what it barely permits. Now, let's return to Schuette, the Michigan case that was before the court this term. As I mentioned, Michigan voters, by passing Proposal 2 by a margin of 58 to 42%, amended their constitution to prohibit all government entities from discriminating on various grounds, including race. A district court upheld the constitutionality of Proposal 2. A three-judge panel of the Sixth Circuit out of Cincinnati reversed in a 2-to-1 decision. But then the Sixth Circuit agreed to hear the case en banc, meaning that all 15 eligible judges on that circuit reheard the case. The Sixth Circuit's en banc panel by a vote of 8-7. Remember, 15 judges, and it was one judge made the difference. By a vote of 8-7, reversed the district court, as had the 3-judge panel, holding that Michigan's constitutional amendment violated the Equal Protection Clause under the political process doctrine, which I discussed before. First, it said, the amendment changed the decision-making authority. Second, it dealt only with racial preferences. And lastly, it lodged the decision-making authority at the most remote level of Michigan's government, the state constitution, making it more difficult for supporters of these affirmative action programs to have their policy preference enacted. The Sixth Circuit's holding directly contradicted our opinion in the Prop 209 case, thereby leading to the classical circuit split. The Supreme Court issued a writ of certiorari to resolve this disagreement among the circuits and to clarify equal protection jurisprudence. Well, the Supreme Court, by a vote of 6-2, Justice Kagan was recused, reversed the Sixth Circuit, explicitly vindicating our opinion in the Prop 209 case. Despite this widespread agreement on the result, however, the court displayed anything but consensus in its reasoning. There were 5 opinions written in the case, and not one was able to procure a majority, which would still have to be 5. Justice Kennedy wrote the lead opinion, referred to as the plurality opinion, and was joined by Chief Justice Roberts and Justice Alito. Justice Sotomayor wrote the lone dissent, which Justice Ginsburg joined. Writing separately, Justice Scalia and Justice Breyer each authored opinions concurring only in the judgment. Opinions concurring only in the judgment usually indicate sharp disagreement among the justices in their reasoning, and this case was no exception. For the sake of brevity, I will confine my discussion to the opinions that comprise the judgment of the court. I will focus in particular on the plurality opinion and Justice Scalia's concurring opinion because I believe understanding the agreements and disagreements between those 2 opinions will be most edifying. However, I will be very happy to answer any questions regarding the other opinions during the Q&A. The battleground for Schuette, just as it had been for us in the Prop 209 case, is the so-called political process doctrine. The court first had to determine if the political process doctrine applied before analyzing its implications in the Schuette case. Justice Breyer, writing only for himself, concluded that the political process doctrine does not apply because the restructuring in Schuette was not, in fact, a political restructuring. It took decision-making authority away from an administrative body and placed it in the hands of a political body. In other words, they weren't moving it from one level of political bodies to another. In both the plurality opinion and Justice Scalia's concurring opinion, the application of the political process cases is not so simple. In entertaining the possibility of extending the political process doctrine to Schuette, both opinions raise a number of constitutional issues. In their respective opinions, both Justice Scalia and Justice Kennedy seriously question whether some of the language in Seattle, one of the political process cases, is compatible with the court's traditional equal protection jurisprudence. The specific language that poses problems for Justices Scalia and Kennedy arises from when the Seattle court, in applying the political process doctrine, determined that the initiative, 1, inured primarily to the benefit of the minority. 2, focused on the racial nature of an issue. And 3, burdened minority interests. Both Justice Kennedy's opinion for a plurality of the court and Justice Scalia's concurring opinion emphasized that these determinations by the court, if required by Seattle, conflict with our settled equal protection jurisprudence. Expressing his agreement with Justice Kennedy, Justice Scalia writes, and I'll quote, "No good can come of such random judicial musing. For one thing, it involves judges in the dirty business of dividing the nation into racial blocs. Moreover, the exercise promotes the noxious fiction that knowing only a person's color or ethnicity, we can be sure he has a predetermined set of policy interests." End quote. But the language of Seattle appears to urge, if not to require, the court to do just that. While the internal coherence of the court's equal protection jurisprudence is important to both the plurality opinion and the concurring opinion, it is not the only concern for these two justices. Extending the political process doctrine to voter-enacted amendments to state constitution raises additional constitutional problems with regard to state sovereignty and our democratic procedures. Expressing concern for state sovereignty, Justice Scalia writes, again I quote, "The political process doctrine, taken to the limits of its logic, is the gaping exception that nearly swallows the rule of structural state sovereignty. The mere existence of a subordinate's discretion over the matter would work as a kind of a reverse preemption." End quote. In the plurality opinion, Justice Kennedy time and again reiterates his concern for the democratic process. In a most telling passage, Justice Kennedy writes, and I quote, "Deliberative debate on sensitive issues such as racial preferences all too often may shade into rancor, but that does not justify removing certain court-determined issues from the voter's reach. Democracy does not presume that some subjects are either too divisive or too profound for public debate." End quote. But Justice Kennedy does not restrict himself to the collective democratic process, for it is his belief in the individual voter that is the basis for his strong deference to the democratic process. As he states in his opinion, it is demeaning to presume that voters are not capable of deciding an issue of this sensitivity on decent and rational grounds. Justice Kennedy, in declining to extend the political process doctrine to Schuette, preserves the power of the people to decide the issue for themselves. Therefore, Justice Kennedy and Justice Scalia agree that extending the language of Seattle to the question before the court in Schuette could present serious constitutional problems. 1, it would contravene traditional equal protection jurisprudence. 2, it would threaten state sovereignty. And 3, it would restrict the democratic process. With these serious constitutional concerns established, Justices Scalia and Kennedy are faced with the question of how to proceed with Hunter and Seattle, the two precedents. There are two traditional avenues to deal with an objectionable precedent. The court can either distinguish the current case from the precedent, or, of course, it can overrule the precedent, something that court can do and our court cannot. The choice between the aforementioned avenues is the fundamental disagreement between Justices Scalia and Kennedy. In the plurality opinion, Justice Kennedy chooses to distinguish Seattle from Schuette. First, Justice Kennedy addresses the problematic language in Seattle, where he says, and I quote, "The expansive language in Seattle does not provide a proper guide for decisions, and should not be authoritative or controlling. Seattle is best understood as a case in which the state action had the serious risk, if not purpose, of causing specific injuries on account of race." End quote. With this understanding of Seattle, Justice Kennedy distinguishes the political process cases from the issue presented in Schuette. And here's what he says. "Here there was no infliction of a specific injury of the kind at issue in the political process cases. Here there is no precedent for extending such cases to restrict the right of Michigan voters to determine that race-based preferences granted by Michigan governmental entities should be ended." End quote. Now, having distinguished Schuette from the political process cases, Justice Kennedy concludes with this quote: "There is no authority in the Constitution of the United States or in this court's precedents for the judiciary to set aside Michigan laws that commit this policy determination to the voters." End quote. Now, by contrast, Justice Scalia, in his concurring opinion, would have overruled the political process cases. Expressing vehemently his frustration with the plurality's interpretation, which he views as a dereliction of the court's duty, this is what Justice Scalia writes. "Though the plurality too disavows the political process doctrine basis on which Hunter and Seattle were decided, it does not take the next step of overruling those cases. Rather, it reinterprets them beyond recognition. I do not agree with the plurality's reinterpretation of Seattle and Hunter, which makes them stand for a cloudy and doctrinally anomalous proposition." End quote. Typical Scalia language. As this conclusion is objectionable to Justice Scalia for the reasons I've mentioned, among others, he would overrule the political process doctrine outright because it is, in his words, patently atextual, unadministratable, and contrary to our traditional equal protection jurisprudence, as he said. Indicating his alternative course of action, Justice Scalia concludes, and I quote, "I would instead reaffirm that the ordinary principles of our law and of our democratic heritage require plaintiffs alleging equal protection violations stemming from facially neutral acts to prove intent and causation." End quote. Well, under such framework, Schuette was an easy case. Recalling my line from the Prop 209 case, Justice Scalia says, "A law that prohibits the state from classifying individuals by race, a fortiori, does not classify individuals by race." Michigan's constitutional amendment, therefore, is facially neutral and does not violate equal protection. So, where does Schuette leave us? The judgment is clear. State constitutional amendments that bar racial and presumably other fixed preferences in college admissions do not violate equal protection. But the principles and reasoning that dictate that result are far from clear. The plurality declined to overrule the political process cases, so they, that's Hunter and Seattle, remain good law. But is the political process doctrine still efficacious in practice? Or, as Justice Sotomayor warns in her dissent, has the plurality opinion's interpretation of Hunter and Seattle effectively cast aside the political process doctrine sub silentio? As a jurist, I always regret such a fractured result from the court, for it is the rationale offered in the court's definitive opinion that will guide all federal judges, including myself, when we decide future cases. Indeed, as a judge on the U.S. Court of Appeals for the Ninth Circuit, I may, in fact, be tasked one day with solving these very riddles. Though you can rest assured that as an appellate judge, I will do my duty to adhere to this precedent faithfully, I will withhold my personal reflections on these questions until such a day. In our exploration of Schuette, we truly see the pivotal role of language in our judicial process. Although Schuette is by no means unique in this regard, it is exceptional in scope. At the outset, we confronted the specific language of the 14th Amendment in order to understand what it permits, or rather, in this case, what it requires. But our venture into the textual analysis did not stop there. We then explored how the justices parsed the language of our prior opinions, Seattle and Hunter, separating reasoning central to the holdings from superfluous dicta. Finally, in crafting an opinion for the court, the justices must balance a desire to procure a majority with the knowledge that it is the specific reasoning articulated in the court's opinion that will steer federal judges in future cases. Regardless of which method of legal interpretation you might subscribe to, from originalism to purposivism, textual interpretation is the central mechanism that motivates our jurisprudence and will continue to do so. Thank you very much. I will be very happy to take any questions that you may have.